On the 23rd of March 2020, the Lord Chief Justice announced that all new jury trials in England and Wales will be halted until they can be conducted safely. So, arguably, those within the criminal justice system most affected by the recent measures are defendants who have pleaded not guilty, but who are remanded in custody whilst waiting for their trial. Now, the length of detention would ordinarily be protected by custody time limits. Now it appears that many trials are being postponed indefinitely, should these defendants remain in custody. The very basic position of the custody time limits is this: the less serious cases are heard in the Magistrates court as summary offences. The custody time limit there is 56 days. For cases that can be heard in either the Magistrates court or the Crown court, the applicable custody time limit is also 56 days. If a case progresses to the Crown court, the limit increases to 182 days. Now, limits will vary in certain circumstances, for example where a defendant is granted bail and later fails to surrender to custody, so is remanded back into custody. But that's the basic position. If it looks like a custody time limit might expire without a defendant having been tried in the Magistrates court or the Crown court, the prosecution can apply to extend the time limit. Again, in basic terms, a court will grant an extension if the prosecution can satisfy the court as to good and sufficient cause. Now, there's no definition or list of what that amounts to. It's for the court to determine on the facts and context of each case, balancing the interests of the defendant against the public interest. If the prosecution's application is rejected, then, subject to an appeal by the prosecution, the defendant has an immediate right to bail, most likely subject to conditions whilst they wait for their trial. So, does the COVID-19 situation provide the prosecution with good and sufficient cause to extend time limits in every case? Well, a recent ruling in a case at the Crown Court saw the time limit due to expire on the 23rd of March, the date that the lockdown started. It was apparent that due to the pandemic, the trial would not begin by or on that date. So the prosecution therefore made an application to extend, and the court considered whether there was good and sufficient cause and whether the prosecution had acted with all due diligence and expedition in the preparation for the trial. The prosecution argued that the statement of the Lord Chief Justice about the necessary adjournment of trials in itself amounted to a good and sufficient cause. Now, the defence accepted that the prosecution had acted with all due diligence and expedition, but argued that these novel circumstances should lead to a refusal of the application, primarily because there was so much uncertainty about a new trial date. Now, the court allowed the application and therefore extended the time limit, although the judge commented that applications in the current climate required a careful balancing exercise between the defendant's interest and the wider public interest. And interestingly, the judgment suggested that the balance may shift depending upon the length of the COVID-19 pandemic and in turn the length of the pre-trial detention. Now, separately, the case made a brief reference to bail applications. In basic terms, a defendant can make two applications for bail and requires a material change in circumstances to justify a third, although the court is bound to consider bail at each hearing. Now, my view is that the current situation could in some cases amount to a material change of circumstances, and defendants in custody awaiting trial shouldn't simply wait for an application to extend the custody time limit. They should seek advice on whether they might sensibly apply for bail in advance. And I say this for two reasons. Firstly, the defendant might be in a high-risk category so far as COVID-19 is concerned, and time could be of the essence. Secondly, the Minister of Justice in Northern Ireland recently announced an intention to apply their Rule 27, which is Rule 9 of the Prison Rules 1999 in England and Wales, to facilitate the early release of prisoners serving particular sentences because of the coronavirus pandemic. Pressures mounting from the prison service unions, Amnesty International and others to see this measure rolled out more comprehensively in England and Wales. Now, prisoners serving relevant sentences are being identified by the prisons for early release in accordance with the criteria set by the Minister of Justice. I won't explain that criteria here because it's not straightforward and will probably change over time. However, bail applications by prisoners awaiting trial should refer to these policy decisions and the related conditions of early release. These are unprecedented events and they call for a novel and constructive approach to whether prisoners in suitable categories should really be in custody. In addition, a failure to seek this advice and merely rely upon opposing an application for an extension of the custody time limit might be met by opposition from a prosecutor who says if this defendant had really been determined to seek release, he would have argued a change of circumstances by now, and he hasn't. So it's clear that the current coronavirus pandemic calls for careful consideration of custody time limits and whether a new bail application ought to be made in light of an apparent change in circumstances. I'm Evan Wright, and thank you for watching.